warm summer evening. We are here to talk about a ballot question. So August 2nd, we have an election here in the village. One of the questions on there relates to marijuana establishments and an ordinance. Did everybody grab a copy of the information that was on the back table there? So there are a couple things. Feel free to read along with me, but there's a question. And a lot of times when you are standing there at your polling place, you're over at the senior center, and you're in the booth, and you use that big magnifying glass, and you say, what does this question actually mean? It can be pretty unclear sometimes. So the reason we are getting together to discuss is so we can clarify. You have an opportunity to ask questions about the ordinance, about this exact ballot question. It's one that has come up in plenty of municipalities, this question or similar. And so it's one that we want to have every opportunity possible to discuss, address your questions, make sure you are the most informed voters that we can be. Sound good? So the question is spelled out for you. It's on that sheet. There's plenty of room on there, so if you want to take notes or write down your question or anything like that, feel free. That's why that doesn't take up that much page. But it says, shall the village adopt an ordinance, the full text of which is on file with the village clerk, pursuant to Section 6 of the Michigan Regulation and Taxation of Marijuana Act, to wit, an ordinance to be known as the Adult Use Marijuana Establishments Ordinance, to provide for a number of adult use marijuana establishments to be operated within the village, and which ordinance would repeal Ordinance number 70 of 2019. Yes or no? That's as clear as a bell, right? We're good? Done. Thanks for coming out. No, not quite. Okay, so because it can be confusing, this is our village attorney. This is Mike Gilder. You'll hear from him in just a second. But we have prepared a couple of things to help you. So one of the things back there on the table is the summary of the proposed adult use marijuana establishments ordinance. You can read that. I can go over the highlights for you, but the ordinance spells out for us, it spells out exactly what that question means. So a yes vote or a no vote are your two options on August 2nd. A no vote means no. This ordinance is dead right now. It doesn't, it goes away. The ordinance number 70 of 2019 remains in effect. It stays that way, and we move on. A yes vote means that this ordinance comes into effect, and the summary spells out what exactly is in that ordinance. Not all of us spend a lot of time reading and writing ordinances, and so a summary can be pretty helpful to break it down for you. If you want to read the full text, mine has post-it notes all over it, but feel free to read it. I know it's tiny little print, that's why they give you the magnifying glass when you're in the voting booth, but the summary is there. It spells out things related to the process for approving retail marijuana establishments up to 2. It spells out the hours of operation, who, where, when, things like that. It also creates a scoring system for the village to decide who will be permitted, which applicant receives that. It also spells out new responsibilities for the village office, for the village officials, for village staff. The clerk has several items that are very prescribed for the clerk to enforce the ordinance to make it happen. The zoning administrator, that's me, that's one of those other duties as assigned that's in the fine print when you sign on as village manager, would have additional things as well as the planning commission. Planning commission has lots of experience with ordinances, but we can talk about this one in particular. Building inspector and building official, so regular village functions continue, but there's a lot of extra responsibility with that. So, village council continues to work to ensure everyone knows as much about this as possible. As the village manager, I do my best to remain neutral, so I don't really have an opinion, just if yes, then, if no, then, is what you're going to get out of me. Our village attorney is here to speak to the particulars as well. So that's my opening monologue for you. Questions so far? Yes.
I just looking over this ordinance very briefly, one thing that I do not see in here are the zoning laws. that are involved with marijuana establishments, so I looked this up a couple of weeks ago. And one thing that I found, according to the medical marijuana facility requirements in section 18404, it says that this has to be in M1 or M2 zoning district. And when I pulled a zoning map, there's none of those in the village, first of all. Second of all, it cannot be within 1,000 feet of a school. We have Harvey Swanson right over here. Or daycare facility. There used to be a daycare facility right up here. So it also cannot be within a residential zone, and it cannot be within 200 feet of a residential zone. So my question to you is, where are you going to put these?
It's ultimately not up to us to decide. That's up to the applicants to figure that out. It does prescribe the where and the how. Be careful, you mentioned the medical marijuana, and this pertains only to the retail marijuana. So, state of Michigan is we love Michigan, right? There are 3 different marijuana laws that are all on the books and all in force right now. One is strictly medicinal, one is recreational. The MRTMA is that one that, and then there's another one as well that is more about medical. So normally when you open a new law, you say this replaces this other law, but no, with these we've stacked all 3 on top of each other. So there's things that overlap, there's things that are totally different depending on what is being sold there. So is it strictly retail for recreational? Is it retail but it's medicinal? It's all different. And this ordinance deals specifically with recreational retail.
Are the zoning laws different?
Probably, I'm not sure.
I know that according to the safe zones for the schools, I'm sure that recreational is not different. If anything, it would be more, would be my guess.
Yeah, if I could, again, my name is Mike Gilmer. I'm the village attorney, and I'm going to answer that by way of some more background, which will, I'm sure, head off some other questions, but answer your question ultimately. I represent a number of communities, and I've drafted a number of ballot proposals. This is the first time one of my communities is going to have something on that I had nothing to do with. Okay? The village manager had nothing to do with, and village council had virtually nothing to do with. So this all pertains to adult use marijuana, the most recent of the 3 that Ryan mentioned. That statute is unique in that it says, first of all, the legislature was going to leave it to each municipality to determine whether they wanted this in their community or not. Opt-in, opt-out are the 2 options. Subject to a referendum by the people. So no matter what the village did, if it opted in, the people by referendum could put a ballot proposal to force them out and vice versa, okay? So in this case, the first paragraph of this ordinance is to repeal ordinance number 70. Ordinance 70 was when the village opted out, said we are not interested in this at all. We don't think it's right in our community. That prompted the referendum where this group came forward. They circulated enough petitions to force this on the ballot, okay? When the village received it, the village decided, largely at my advice, that, listen, we don't think those petitions are sufficient, legally sufficient. We're not bound by that. We're not going to put that on the ballot. We want to stick with our opt-out. That group took us to court. The judge ultimately ruled this has to go on the ballot. So what you see tonight, all of the language that has been summarized and is back there, was prepared not by me, but by this group of marijuana supporters. Okay? So I look at this, and as I told the village when I first received it, there's a number of things in here that to me are unusual, to say the least, in some cases offensive, but we had no choice. This is put on the ballot because the judge has told us to put it on the ballot. In answer to your question about the zoning, the only requirements of this ordinance are found on the bottom of the first page of the, what's called at the top, local proposal. And this is written so small, but I think it's section 5 at the bottom, where it talks about locational restrictions.
Oh, I know.
I think.
I was just under section 13 for activities.
I'm sorry, you're right. It's section 13, activities prohibited, are the locational restrictions. Again, the language here, prepared by someone else, specified that had to be so many feet from this and can't be closer than that, has to have so much vehicle traffic, etc. The village determined that there were very few parcels in the village that met all of those qualifications. I have a very sneaky suspicion that the folks who put this on the ballot know exactly where those pieces of land are and probably have dibs on them already. But those are the only locational restrictions.
I have a question. Is this meeting going to be recorded in any way, made available to the public?
They are.
OTV, you'll see in the back there, yeah.
Thank you.
And we'll continue to work with OTV to make sure voters are informed. Those who can not attend one of our evening sessions we have tonight, and then again on July 11th, we'll have a similar get together.
Okay, so following up on Heather's question here, as I recall from prior investigation, there's only 2 locations. One by the light and then 15 by the A&W. And the other one out by Jeff's Pizza just north in that little strip area by Barris and right in there. Am I correct?
You're close. I'm not entirely sure. It gets confusing with the, it's spelled out in section 13, the 850 feet from a K-12 school, but that's from the building of the school to a property line of the establishment. So the way it's spelled out is very confusing at a glance, and that's why I hesitate to say this is the spot. The caveat in there that it has to be a standalone building on a road that sees 20,000 or more cars per day does mean it's got to be on M15. It wouldn't be downtown at all. It would have to be on M15. It's the only road in the village that sees 20,000 cars per day.
So where the cabinet shop is right now, it's got to be close together, 50 feet away from the outside corner of the middle school.
I'm sorry.
I'm not sure.
No, you're selling that.
I'm not a surveyor.
You're not talking about old middle school that's no longer middle school.
Correct. That's no longer a school building.
Correct, because that would not count
That's also,
as a.
no, I'm talking about
The Harvard-
Vermont and the cabinet.
Well, but the library is also right there, and it has to be away from the library as well.
Only what they have in here, so you gotta read that.
It
And
doesn't have anything to do with the library.
it says nothing about libraries and it
No.
just, yeah.
Nothing.
No, so Heather, it is?
Yes.
When you are referencing what other locational restrictions are, or what any other statute says, that does not apply here.
But that came right off of Michigan.gov.
Understand. However, the language that is before you is exactly what the judge ordered be put on the ballot. And that is what the statute unfortunately allows. So those other things really do not come into play.
Was there an opinion and order issued by the judge that we could read?
Sure,
Yeah.
yeah.
Did not print it, but.
You did not
do have
print it?
Yeah.
Okay.
I can, I'm sure I sent it to Ryan. I'll make sure I send it to him again tomorrow.
Okay.
And he can make that available to whoever wishes to see it.
Okay.
Is that a ruling that can be appealed?
It could have, probably.
It is, frankly, and there was a discussion about doing exactly that. The decision was made not to, And I can't go into all the particulars of that, except to say that there was discussion about looking at this and seeing that there's only maybe 2 or 3 places where this could go. And the village wasn't even sure if those parcels were even available. The decision was, I guess, take what we know versus what we don't know. And I don't want that to sound like, we welcomed it, because again, we did not welcome it. But there was discussion with council about your options.
I've got another question. So one of the other issues in talking with some of the township trustees, there's also an ordinance in the township against having these facilities within the township. Does this replace the ordinance in the township, being that the village is within the boundaries of the township?
So this is a village ordinance. If it's adopted, this is a village ordinance only. It does not replace, it really could exist separately from anything that the township has.
Well, one of the issues that I think will come up is that our fire and our police specifically are township villages, not village villages. And, if history repeats, as it has in Colorado and some of the western states that have had these facilities for quite a while, the incidences of break-ins, the incidences of police reports, the incidences of health issues, surrounding where these facilities go, I think would be an issue. Is this something that's going to push the township to drop the village, or to, force the village to start paying the taxes on the fire and police? I mean, we're already being taxed by the township as well as the village. Is that going to change that relationship?
I've had no communication with the township about this or about the services they provide, so I don't know. And Ryan, I don't know if you're in any position either, but.
Ryan? I'm a village resident, and I pay the taxes for that police and fire, like everybody else. That's all. I just want to say that, make sure they understood that we're all equal as far as that goes with the township.
Without do all this stuff, is there anything that states in here that you have to have a certain amount of police coverage, or in the village to increase that?
No. The closest it comes is that, so the way this works is if adopted, right? And so that's the first big if adopted, what this requires is that there be no more than 2 establishments, and those 2 would be selected by an application process. Applicants have to submit an application along with the fee, and the application must include, among other things, an operational plan, and specifically about safety and protection, those sorts of things. So that has to be provided. And then there is a scoring system, again, built into this ordinance, where once all those applications come in, the application window closes. It's up to the village clerk, first of all, to score them according to this schedule. And then those go then to village council, and the top 2 get it. So the closest that we come to any sort of police coverage is, what are they proposing by way of security for that, for their application?
So that's gonna be like a #1 question then, what's their security measures if they bring it in?
It's one of several things that have to be indicated in the application.
Yep.
And the scoring is,
It's in section 12, is the scoring system. And then after selecting of the 2, each applicant would submit a site plan, and that's where the planning commission and the zoning administrator get to work very closely to review site plans. And that's where it provides for security measures and safeguards against odor in or out type stuff. All those things that it would need to be spelled out in the site plan before it's approved that they can start work. We would have to make sure all those things are provided for. Planning commission.
Does the ordinance require, not require the individual to own the property and building, or can they lease a piece of property and put that in?
There's a section.
Now you're going to make me take off my glasses and read the very fine.
That's what you're here for.
While you're reading that,
I'm
can I
wondering,
ask?
I'm
No, they're both reading. Does Jenna have enough time to do all this? Because I'm sure we're going to get more than 2 applications. Is my guess. I'm just guessing. So Jenna, she doesn't just sit around and eat bonbons all day. She has work to do. Is she going to be able to do this as our clerk?
So Jenna Palmer, our village clerk, works 30 hours a week currently. There are quite a few demands on the village clerk within the ordinance. So if adopted, it would be a challenge to complete even everything in this ordinance. Especially during the application window and in the creation of the application packet and all that good stuff. There would be a lot of time invested. With our current staff, could we do all of it? Maybe. Would other things slow down or stop? Maybe. It's hard to say. It would require a lot from village staff in addition to regular other duties.
But if it required to own the property, that means you're only going to get 2 applications, right?
I'm not sure about ownership.
Yeah, I'm
There's a
sorry.
transfer option.
I'll continue to try to
If
find
they
it.
can transfer.
Yes, there's language about transfer.
So if they can do that, obviously they don't have to own.
I would think so.
The building.
I would think so.
Because I have questions on the transfer, so, but I'm not certain, but that's something we have to definitely find out. But they can transfer in here,
Okay.
so we're not gonna own the building if they transfer.
So I have a question. If this passes and this language that was specified by the judge has to be what it is, if it is later found to be in some conflict with the Michigan law for recreational marijuana, what happens in that case?
Well, anything local gives way to state law. So if, and this is all premised on state law. So if there's a subsequent decision that MRPMA, the adult use marijuana statute under which this was adopted is unconstitutional or unlawful, I think it's right back to the drawing board with this and anything else.
Section 22 specifically addresses state law and the 3 Michigan marijuana acts.
Wayne,
state
you
law.
had your
Yeah,
hand up.
So there are a lot of variables, many of which are going to be affected, as was mentioned earlier about the time on task of our staff, not just the application process, but the eventual enforcement. And I don't
Site
care,
plan
issuing
review.
tickets, I don't care what it is.
Permitting.
Because, this is not a brick and mortar issue, this is so we have a building official now. So if we have to incur additional staffing or time on task by our current staff, other than section 14 where it talks about fees, which are being capped at measly $5,000 per year per application. That's per application, I don't know about an annual fee.
It is.
It's annual fee, okay.
Number 6 has
Number 6.
annual as well. It's just
Is
licenses.
that a fixed fee or is that a graduated fee based upon sales?
No, it's, the 5,000 is set, it comes right out of the Michigan statute. It can be up to 5,000, no more. And it can be an annual, a recurring fee. So it can be, once the applications are first reviewed, and then if they have to renew on some periodic basis, it can be imposed again.
So why is it a not to exceed $5,000 fee when our expenses for our staffing might be 15 or 20,000?
So that application fee just anybody who applies gets to pay that up to 5,000. The fee could be less, it's up to the village council.
I'm talking also
But
about
then,
ongoing
in addition,
enforcement.
Yep, so there are some for, if you're getting inspections, there's a fee for that. If you have to submit a site plan, there's a fee for that because it requires the entire planning commission and it requires lots of legwork, things like that. So there are some fees. The planning commission is working on updating the fee schedule, as well as the site plan review process, because it's one that the village has been built out for a long time. In our process, we're working on it because.
So
it needs to be
nowhere in
updated.
state statute is there a proviso that allows us or any municipality to have those fees based upon a percent of sales.
No, that's true. The 5,000, my guess is that that's what the intent was, is that it would absorb some of those additional expenses, and that's what it's for. But there is nothing in state statute which enables us to pass anything beyond that on to the applicants.
Point of fact, the water company out on the west side of the state up by Stanton or Mid Rapids, they have to pay a $250 a year fee, and yet they're taking billions of gallons of our water and reselling it. And we, that locale, gets nothing other than that fee.
Correct.
It's just absolutely ludicrous.
So as we're talking about revenue, the state statute also calls for revenue sharing among municipalities that have licensed retail, recreational facilities. This year, each municipality received about $56,000 per licensed place in their municipality. So if we had two, in theory, we would have received $110,000 from state revenue sharing. It's I want to say it's 18% of the state's tax collected related to the MERPA Act. If that gets shared to municipalities, that number is likely to go down in the future as more municipalities open retail recreational facilities. That's what we've seen in other states and in other places, but there is some revenue from that as well. That can be expected, some. It's hard to say how much.
But is that the pure definition of revenue sharing is based upon revenue? So some of these establishments just getting started may not show much revenue in year 1 or 2.
Correct.
So that's going to be a sliding graduated thing from the state.
Well, and to that point, and that's a good point, I'm glad that Ryan raised it. What happens is all of the taxes that are generated from all of these establishments in the state are dumped into this big pot. And then it's paid out to the municipalities who have these establishments in a proportional basis. So you're not just looking at the profits from your two establishments, it's all the money from the state, again, in a proportional share.
Thank you.
Can we talk about a little bit 7 and 8, so the municipal license renewal criteria? Does that mean once they get a license, they are there until they become a felon or something happens?
That's right. That isn't in section 7. It's later on where it talks about.
I'm so sorry. Yep, that was number, it's in section 5, granting conditional license approval, and it's number, yes. Number, I got the right one. Anyways,
It's section, I think it's 8, criteria for revocation.
yes.
Those are, right, it indicates in subsections A and B, the 2 ways that revocation can occur. So in essence, if they pay, if the village imposes an annual renewal fee and they pay it, then the only way it would be lost is if they met one of those conditions for revocation.
And then I had a question, since we're in that area right there. So number 9, the limited right of appeal
So section 9 says that an applicant, remember, this is all done by, maybe you have 10 applications, but there's only going to be 2. And it can only be 2. So we score it, and village council says Smith and Jones gets it. Those who don't can appeal under that section within 21 days to circuit court. Now, that section can't be found in state statute and hasn't been tested in the courts as far as I'm aware. And so I think a circuit judge might say, well, who says you can appeal within 21 days? I mean, a village ordinance usually cannot confer jurisdiction on a court. The courts tell us what the process is for appeals. And so, as I sit here right now, I'm not entirely sure that Section 9 is even going to be enforceable or recognized by a court.
Okay, and we have no other community that has an example of any of this
No.
at all?
No. So
Okay.
the first marijuana statute in the state was done in 2008, and much like this version here, left much to be desired. And the only way that there was some definition provided was a series of court cases, slowly and over time. And of course, every case usually just focuses on this little area, and then another case focuses on this other separate area. So it took years before really lawyers and judges in the state had a clear picture of what the 2008 law meant. It's because it had to take that process. And I suspect it's going to be the same with this.
Will we be responsible for court fees every time they're appealing an application denial?
No, there are no, first of all, this ordinance doesn't provide it. Number 2, as a general rule in this state, each side is responsible for their own attorney fees unless there is a recognized exception, and there isn't for something like this.
But we have to pay us.
You'd have to
So
pay
the village
yours.
would,
Over and over and over.
out of 10 applications to get it, the other 8, if they all take us to court, we would have to pay and fund at the village.
Yeah, unless they're making a claim for money damages, in which case you may have insurance coverage, and the insurance company may pay for it. But again, this is talking about an appeal, and generally there's only insurance coverage if the party suing you asks for money, not just to reverse a decision that was made.
Maybe you could go over some of the benefits and the non-benefits of having it. When we talked to council, there were a number of, last time we talked, there were a number of issues, both pro and con. And maybe if you could offer some of those up, that would be helpful to those.
Well, I don't know that how well equipped I am to talk about the benefits of having this in place, because I'm not a marijuana business lawyer. My experience is generally representing municipalities and what they experience. What jumped out at me, some of the glaring things in this ordinance, is this whole business of you're limited to 2, let's have this application process and this scoring, and it's got to be objective and it's going to be fair. I live just outside of Lapeer. Lapeer did this years ago, and they said we're going to have 6, no more than 6. They had something like 35 applications, and applicants 7 through 12, I think, sued them because they weren't chosen. And the city, they took their applications and they sent it to some place down in Tennessee or Kentucky, some outfit that was responsible for doing the scoring, doing the things that Jenna has to do, for example. So in other words, they had some outside eyes looking at these things, and they still got sued. And to my knowledge, some of those cases are still pending in Lapeer County. So the idea that there's going to be this objective scoring system and it should just answer all the questions, I think tends to generate other questions that are out there. There's a provision in here. I mentioned the one about the appeals and whether that's even something that they can do. Section 19 says that if the village wishes to amend this ordinance, we have to give so many days' notice to all the businesses that are operational and give them advance notice that we're going to amend it. As a municipal lawyer, I find that offensive. I mean, the village transacts all of its business in an open meeting. We mean to be transparent, but we do not single out people and give them notice that is different than others that may be interested. And this requires that we do just that. It's those sorts of things that I question. But again, that's probably more from a municipal lawyer's perspective than anything else. And I suspect that if the committee that put this in litigation and forced it in your lap, they would say, listen, you're going to get $5,000 per application. If you get 30 applications, it's times 5,000, and you know you're only going to get two establishments. That's extra money in your pocket. And as I mentioned, there's going to be this pool of money that everybody shares, and the tide raises all boats, sort of thing. And in dealing with the lawyers who represented this group, they said, if you look at the statistics of those who voted in the village for the marijuana, the overwhelming majority supported marijuana. And
In
so
the state. You're saying.
In the state, exactly.
In our case, actually, it was 60% voted.
Yeah.
It was in the state election.
On the 2018 question.
Yeah. So,
But that was more for personal use versus dispensaries.
well,
For recreational
I
retail.
don't think it,
there's,
How many people did not understand?
yeah, and that's just the issue, right? Is, in 2008, when we were talking about medicinal marijuana, I think we were all thinking about 95-year-old grandmothers with glaucoma and cancer. And we weren't thinking about 23-year-olds who claim about migraines, for example. So what the voters really knew and what they were supporting when they voted it, that's not for me to say. I'm just saying you asked what may be the pros, and I suspect that's what you would hear from those who are supportive of it.
and I guess I was referring to, like we talked about, there would be an increase based on other communities, what they've seen. There could be an increase in police, there could be an increase in the amount of time it's might probably have to hire someone to do a lot of this stuff because of the legalities of it all, and our clerk, as wonderful as she is, probably is versed in all of the laws that go along with this ordinance, if it were to pass.
Yeah, there's going to be a lot of incidental after effects if this passes, and I don't think anyone really knows what that will be. There are a number of communities that have adopted ordinances like this. Some of mine have, and we're still waiting to see how it all really plays out.
Can you touch upon the implications of section 20? In terms of being able to make changes and modifications to this ordinance?
I think that section 20 is the most glaring piece of evidence that the Village Planning Commission and Village Council did not adopt this, did not create this ordinance. It speaks to changing this ordinance in any way and a waiting period to do that, which I don't think we would tie our hands behind our back if we had read that.
That's a true story. That's a true story. I have never, I have adopted, or I have prepared ordinances that had sunset provisions. That's not uncommon. But to say that once you adopt an ordinance, your hands are tied for a period of time, the case law doesn't support that at all. An ordinance is legislation. Can you imagine?
Here, a period of 3 years.
3 years. So, I mean, can you imagine at the state or federal level where there's a piece of legislation that's adopted and they say it's fixed in stone? You can't change that for a period of time? I've never heard of that before.
So who was the judge that allowed this? And
That's what I said.
What circuit or district was he or she in?
Oakland County Circuit Court.
No, the circuit court. And who was the judge? Who was the judge?
I believe it's Cheryl Matthews, I think. Don't hold me to that. Before anybody sends any messages, let's clarify that.
I'm sure that was her name.
And in any event, if it's her or someone else, that ship has sailed a long time ago. So I wouldn't want anybody to reach out to
How can
them.
we accept, even though if it's voted in, we have to accept it, section 19 and 20? I mean, that's ludicrous. I mean,
Why can't the village council just appeal that part of it? Leave the ballot initiative on there, but get rid of that part?
So, those two sections were two of several that I really highlighted when I was arguing to the judge. Listen, this petition is faulty, and you should not order this on the ballot for these reasons. And I gave the case law that, you know, our hands should not be tied, we can't give special notice, etc. And her decision was, just looking at the petition, it complied with Michigan election law, it complied with MRTLA, it must go on.
As is.
As is.
Well, but putting it on the ballot and actually adopting it are two different things, are they not? Can it be appealed as far as, you know, these parts that are
No.
not?
No. And we're looking, we've been just looking at the section of the ordinance. The petition itself, which is all that you're going to see on the ballot and all that Ryan read, it references this, but the voters are not going to see this when they go.
That's why we're having these
They're going to see just that little section right
That's all.
there. Yeah.
Up or down, yes or no?
So we're trying to educate people on what they're really voting for.
How do we educate people?
If people aren't all here, I mean, can't you guys post an article in the Citizen or something like that, pushing that out there?
Can we?
We're
A
here.
little bit more.
Write a letter to
So
the editor.
OTV is going to be extremely helpful in educating voters as well.
And I think we are posting the full language of the ordinance.
All of it is on our website, as well as the summary and the question.
And there is another meeting on July 11th, if you can get people to come.
So if we have a no vote from the community, can they come back again 6 months from now and ask for another?
Oh,
Referendum?
they would have to, I think, restart the referendum period. I don't believe that will happen, because what they've said all along is, let's let the voters decide, quite simply. So if the voters decide no, then Ordinance 70, which is the opt-out, Ordinance 70 remains in effect.
How big a group is this residents for Ortonville? Do you have any idea?
No idea.
The petition process, it says that you have to have, and I want to say it's 5% of the people who voted in the last gubernatorial election. So based on the 2018 election for governor, in the village there's 1,500 people. So however many actually turned out to vote, say it's 1,000 people voted, and if you needed 5% of that 1,000 people, you need that many signatures that are verified by the clerk. The township clerk runs our election, so that many, is that 50, right? I'm not a math person, that's 50 signatures. to be verified, to be considered valid.
Technically, that doesn't answer the question about how many people in that group. If
No idea.
people put together a petition, one is through.
Yeah.
Would you mind speaking as to how it came to the how the process of the ordinance came to us?
So, and you're gonna have to help me then, Tanya, because I know, I think you're getting at the timing of it all. It played a
And how the
big part.
process starts, who started it, how the process comes to,
Yeah.
the community.
Yeah, so, again, there is a petition that must be circulated and turned into the township in this case, bearing the signatures and having the language that is here. That language was given to the township and then given to the village for review. They wanted it on the May, if I remember correctly, they wanted it on the May ballot.
November.
Yes.
Yeah.
No,
Is that right?
and
Was it-
then our May,
Deadline.
and then you guys' August, because we didn't have one in there.
Yeah, so, without getting into the weeds, they gave it to us shortly before whatever our deadline was.
Wednesday at 5 PM and it was due Friday at 5 PM.
Yeah. So it got to me, I looked at it, I thought, I don't think that this is at all what the statute allows. I met with the village, I offered that opinion, I said, we can ignore it, we can force their hand to see if they file suit, or we can place it on the ballot, let it go on the ballot. The decision was made that we think it's deficient, and that's how we got here. Again, goes to the judge says put it on the ballot. So it was a rushed process, not on our part, but by the time we got it, we were expected to do something with it by law within a matter of days.
So the organization called Ortonville Residents for Action, do we know do they have a filed DBA in Oakland County? Do we know who their organization, who their organizers are? How are they verified?
We know who the resident agent is.
One person.
Well, that's all that has to be mentioned is a resident agent is usually just one individual. And that was verified at the time. Now, I can't tell you who it was, but that's something that my office did to make sure that they were in fact that organization. Who they are, I have no idea. I never met them. I dealt with their lawyer.
So I'll shamelessly plug, you mentioned getting a copy of the summary disposition and stuff like that. I have them. Be happy to share them. In the back, there's an optional, totally optional sign-in sheet. So if your info's on there, put a star, or I have my business card too. Just reach out. Happy to share that with you. And if you didn't share your info, feel free to.
Can I ask just one last question? It's section 13, activities prohibited. No, it's not. Very bottom of that, section 16, delivery, but it is under section 13, twice, it says section twice. So section 13, activities prohibited, at the very bottom, delivery, section 16, delivery service. The village shall not restrict delivery service hours for this establishment. What does that mean exactly?
Well, again, not being anyone who prepared this, I'm not entirely sure. I think what is meant is one of the establishments that is allowed under this statute is a transporter, where the marijuana product is moved from place to place. I don't know if what that says is if there is such a facility that provides that service, we can't restrict delivery.
So they could get deliveries at 3 o'clock in the morning.
3 a.m. because we have no.
Nope, it does spell out hours. It can only
Hours
operate
of
between 7
operation,
a.m. and
yes,
11.
but this is saying
Is this
delivery to
different,
facility
though? Yeah.
cannot not be restricted. So it means they could deliver at 3 o'clock in the morning.
Yeah, I believe this is different, that's why I wanted to confirm.
I think it does.
No cops
I'm asking,
Trust me.
is this different?
Yeah, well, I think so. I do think it's different. I just hesitate again because if it's something that I prepared, I'm happy taking ownership of all of this stuff. But I read it and I have a lot of the same questions that a lot of you do as well.
Okay, well, that's scary. I'm just saying, because we're looking at you for guidance and direction.
Our lawyers having a hard time understanding how people can understand.
And in fairness, I told you, the 2008 legislation, when it first came out, you ask 2 lawyers, they're going to give you 3 different answers. And it only became clear years after the fact, case after case after case, exactly what it meant. I talked to, in the aftermath of that, I talked to some very smart lawyers in the state who would tell me polar opposite of what they thought that statute meant. So it's a breeding ground for disagreement and confusion. I'd like to be the answer guy, but I'm not the answer guy. I mean, I'll do my best. I'm doing my best, but when I'm asked to comment on someone else's language, it's a bit difficult.
If it's a no vote and we don't repeal 70, what's going to be the process that's going to happen after that? And I know you can't speak specifically, but it's going to depend on what groups or whatever happens, but potentially what's going to happen to the village if it's
Nothing.
voted no.
Nothing.
So what option will that group have then to follow up on it if we turn it down?
They would have to restart the process and submit petitions to put it back on the ballot at some future date.
This same one?
No. They may come forward with some different language. If this is turned down, Ordinance 70 stays in effect, which means there will be no establishments, and the only way that changes, 2 ways that changes. 1, village council on its own adopts an ordinance allowing it on different terms. That's a possibility. Or 2, this group or some other group or person petitions, just like this group, to put other language on the ballot.
At that point, would they have to go back to circuit court and get it approved by the judge to put it back on the ballot?
Not necessarily. The only reason it went to the circuit judge in the first place here was on my advice that I thought the petition was deficient and contained some of these things that I thought were simply unenforceable. So if we get a petition, I don't know what my advice would be to village. It depends upon what that petition says exactly.
Right, I got a question. As far as this being or missing the May ballot for May election, can you explain why that happened and why it's on August, in the August election? And is there anything one that the village has to pay for the August ballot? And is there anything else on the August ballot that's...
Good question. So that's what I was alluding to about the timeline. The judge issued their order in September of last year, which was past the deadline to get things on the ballot last fall. And so we asked the judge to review that. We said, oh yeah, the next possible ballot. It was kind of your choice. So Mr. Gildner met with their attorney and decided which one. They kind of gave us the option. It could be the May ballot or the August ballot. The village council met and discussed this and decided that August would be the preferred choice. The way paying for elections works is the highest office pays for it generally. So if it's a presidential one, the feds pay a bunch, the state pays a bunch. There's a governor's race on the August ballot. The governor's primary takes place on the August 2nd ballot as well. There's also a better turnout generally at the August election, which was one of the preferences of village council, that the more people that see this at the poll, the better. So that's why, given the option of May or August, did we even have anything on the May ballot? I don't think so. So the village would have paid the entire expense, so that's why August made some more sense. Yeah, good question.
I just wanted to make sure that people understood why I waited until August.
And the petitioners went along with that too.
Did-
It wasn't just the.
It was agreed upon, yes. Did that cover it?
Yeah, no, that's exactly right.
So we just sit and wait and vote either on this one, yes, and wait for the next one to pop along to see what somebody's gonna petition an ordinance for us to vote on. That's what it comes
Yeah,
down to.
right now, this is all that you got in front of you. It's all that you got to vote on. And I think all that any of you can do is go out and do your best to educate those who aren't here about what we talked about a little bit.
That's,
As difficult as that is.
yeah, I prefer the ordinance writing to happen with the planning commission. It's my preference too, but
I'll bet you
our planning commission chair.
Just one thought to share on that. If this does get voted down, but either it's close or we hear a lot of feedback that there is a desire in the community, I think it would be something that council could do to work with the community to find out if there really is a serious interest in having this, an establishment in our community. So then work through our own process to come up with something that would fit. And I think that would be a process that.
Why would we do that if they already voted, everybody voted no if they
Well-
voted at the election? Why would we
Everybody
vote
knows.
no?
Well, I can share a little bit of my experience going back to when the original opt-out ordinance was put in. When the recreational marijuana law passed, the ballot proposal passed, there was about 60% of our Ortonville residents voted in favor of that. So a majority of residents did vote in favor of that. However, the council took a very quick decision to say, no, we opt out. From my perspective, I was on council at that time, and I felt that we had more time to study it a little more and get more input from the residents and such at that time, but that was overruled by the majority of council at that time. So we never really engaged the community or did a lot of research on the implications and how it would work and stuff like that. If we have feedback from our residents that, hey, we would not be opposed to it, but we don't like this situation, and that's why they're voting no, and we understand that could be the case, then it could be that we may want to revisit that and just make sure that we are listening to the will of the people and the residents themselves before we just automatically just say, no, we're just going to stay opted out. I'm just saying it could be something we could reconsider and just see if there's interest in that.
And to me, the only time that would make sense, if we felt that a body, this body, or anybody was going to keep coming back again.
Yeah,
We had to incur more attorney expenses.
Have something forced on us like this that we don't have any control.
And I have one more question, and this is more. Okay, so I know there's a lot of provisions in here for the clerk. After applications are submitted, she has, so many days to get that, and council only has 30 days to approve it, and she has so many days.
Right.
And our meetings, right now, the way it's set, so under these guidelines, I could see that we would not have those done in these timeframes. Number one, we don't have the manpower. Number two, our meetings are set that way. So would we have to call special meetings to be in aligned with these?
Potentially,
Yeah,
potentially.
so that's more potential. Okay.
Or created section 21 municipal inaction.
My name's Cindy.
Yeah, I was doing section 12, village responsibilities, that whole thing, 45 days, 30 days. It's just the way we're set up is, yeah.
If this wasn't passed in August, when would the process start?
like the
ordinance
next
shall be
one.
used 10 days
Okay,
following
yeah.
order approval of the
Yeah.
proposal and shall be codified by the village according to the usual practice.
Yeah, it
So-
starts wham bam.
So 10 days from the election, if it's passed. And then, so Jenna could be signed
Ballot.
10 weeks.
Well, first, this provides that we shall prepare an application form for people to fill out. And if we don't, then people can just turn in applications that, as long as they cover some of the detail in them. So if this passes, I'll be in contact with Jenna and Ryan, Lickety Split, to talk about how do we implement this within the restrictions of this ordinance as best we can.
The wording on that, without putting a retired members of the township clerk's office, an election expert on up here. Passes, verified passes, passes on that day, what's passes? Because it's not verified,
To the Board of Canvassers.
certified, see,
Several-
that's why she's
Yes.
here, certified. So how does that actually, exactly?
We don't know yet.
It doesn't say.
It doesn't say.
It's so murky. It really is, that whole submittal and review.
I can tell you, when I was talking, so as Ryan mentioned, the judge's opinion came down sometime in September, and anything for the November ballot has to be certified, given to the county, usually the first part of August. So that time had already passed. And so when I'm talking to this group, this advocacy group, and I said, we can't put this on the ballot. And by the way, we don't even put this on the ballot, the township does. They had no idea about those details. No idea. They're proposing marijuana, that's what they support, and they don't know those details, how those things play out. So again, that speaks to the fact that there's language in here that a municipal lawyer would not put in here because it just is not workable.
So how do we get answers to those questions?
We're gonna, first of all, do our very best, if this passes. I'll be in contact with the village the day after the election, and we'll do our level best. And if we can't do something because it's just impossible, like putting something on the November ballot, when we simply can't, we'll have to show this group that it's through no fault of our own.
If it does get on the ballot, can we do another citizen-led initiative to get rid of it next year?
That's a good question.
I mean, a lot of people, when they fill out that section, they just, without even reading it a lot of times, they check yes.
I-
So,
Anything
Is that
that,
possible?
anything that is put on by referendum, can always do a referendum to undo it. We're-
Wouldn't we have to wait the 3 years that it says? I mean, that's what I don't know.
not a
I don't-
citizen-led, right? I mean, a citizen-led is a different animal. than-
Yeah, that section talks about the village council can't do anything, but just like this is foisted on us, if there's a subsequent petition that changes it, we're not doing anything. We're just following the will of the people. I try not to get any further than where we have to be, right?
Yeah.
Lots of things can happen. Right now, we're looking at August.
Okay, there's a few of us that haven't asked any questions. Last call for questions. If anybody's got them, now is the time.
So what will be different about the July 11th meeting then? Is it going to be the same kind of thing? Will we have some answers to some of these questions? Is it possible to get those answers or?
I've read this so many times since last summer that if I don't have the answers now, I'm not going to have them in 2 weeks or so.
Yep.
But my understanding is it's just a repeat of this. So hopefully just to get a different group of people. Yeah, a different group of people so that the word spreads.
That's where we can use your help to spread the word, let people know, check out OTV, refer people there. And if you do have questions, if I've got your info, I'm happy to share with you. If you don't have my info, come and get it. My business card's right here. Happy to answer questions when you have them, refer them as needed. But thank you for coming out on a hot summer night. Greatly appreciate it. I'm encouraged by our attendance, actually. I don't think it's a small crowd at all. I think it's a good showing of people with very good questions. Thank you for being here, being engaged, being an informed voter. That goes a long way.
Well, thank you for putting it out.
Thank you. Yeah.
Thank you.